Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am our Executive Director and Vice President of Legal Studies. Those of you not familiar with the Foundation, we are in our 48th year of free enterprise advocacy, education, and litigation. This is one of the programs that we do to try to educate the public on a pretty wide range of issues. If you'd like to learn more about the Foundation, please check out our website at wlf.org. So it's generally perilous to forecast the new administration's law enforcement priorities and strategies at the beginning of administration, because unpredictability seems to be, in part, the modus operandi of this particular administration. It's all the more perilous. However, we do have the benefit of Mr. Trump's first 4 years in office, so our speakers today at least have something that's somewhat of a starting point. We also have statements during confirmation hearings and the official actions and words of some officials who have served in the same or similar positions in past administrations. And of course, our speakers have many years of experience in and outside of government to inform their insights on white collar, antitrust, and securities. We have a lot of ground to cover, so I'll start by introducing our speakers. Greg Brower is co-chair of the Government Investigations Practice Group at Brownstein, Hyatt, Farber, Schreck, located in their Nevada office and here in DC as well, Reno and Las Vegas. Prior to returning to the firm last March, Greg served as Chief Global Compliance Officer for Wynn Resorts. His career in public service includes positions as Nevada's top federal prosecutor, as an FBI senior executive, Inspector General for the U.S. Government Publishing Office, and Chairman of the Judiciary Committee of the Nevada State Senate. And most near and dear to our heart, he's a member of our Legal Policy Advisory Board. Emily Garnett is a shareholder practicing in Brownstein Hyatt's Denver, Colorado office. She's a versatile securities and antitrust lawyer who uses her government experience, public policy background, and litigation skills to advise clients on high-stakes regulatory enforcement and litigation matters. As a counsel with the SEC, Emily was lead investigative attorney working on cases concerning potential violations of federal securities laws, including insider trading, registration requirements, cryptocurrencies, and fraud. We're also pleased to have with us today Alan Grunes, who's also a shareholder at Brownstein. He is skilled in the full spectrum of competition law issues, often assisting clients in developing government relations and public relations strategies in high-profile matters. He previously spent more than a decade at DOJ's Antitrust Division, where he led many merger and civil non-merger investigations in radio, television, newspapers, motion pictures, and other industries. I want to remind everyone we're recording this afternoon, so just so you know that. And then if you have questions for our speakers, we'll address those at the end. Please use the Q&A function located in the Zoom webinar toolbar to ask questions. Now, we're going to go by a sort of question and answer approach here as well, but we'd like to do sort of a brief opening statements. So Emily, if you could get us started with your thoughts initially, please.
Yeah, thank you so much, Glenn, and thanks for the opportunity to talk to you all about securities issues, which I think about all the time, but appreciate that our audience may not. I think that this second Trump administration is going to be quite the departure for securities enforcement from the first. When President Trump was in office the first session, the first term, he had Chair Clayton. Chair Clayton was very kind of I'd like to say plain vanilla. His approach to enforcement was very predictable. There was a lot of transparency. There was a lot of continuity with staff. Staff was overall very supportive of his philosophy, even if it meant that, you know, there may be cases that didn't have the political support to bring, or there were rules that were not brought across the finish line. Chair Clayton was very kind of consistent with the general orthodoxy of the SEC mission, which is to protect investors. Chair Atkins, in comparison, has had experience as a former commissioner, but I think we know from that experience that he is going to be more aggressive on a deregulatory regime, and I think he's going to be very sensitive to enforcement through cases. So while he is no friend to Ponzi schemes, I do think that he's going to show a much more favorable crypto approach, in tandem with the fact that the overarching theme, it seems to be, with President Trump's inauguration is to get government employees to resign. So I think there's going to be a lot more tension on the ground with the career enforcement staff. So it'll be exciting times in the securities world.
Thank you, Emily. Alan, initial thoughts?
Thanks, Glenn. And also, I'm happy to be here. I love Greg and I love Emily. Brownstein is a great group to work with. I'll start with a statement that was attributed to Yogi Berra. It's tough to make predictions, especially about the future. The first Trump administration was not predictable. Who would have guessed that Trump 1 would bring the first big tech monopoly cases? Who would guess that Trump 1 would be the administration that for the first time focused on labor markets? Who would guess that Trump 1 would bring the first litigated vertical merger challenge in 40 years? But it did all of those things. The Biden administration, in some ways, put those issues on steroids. I think Trump 2, they're going to come off of steroids, but they're not going to disappear. So still there are a few fairly important changes that are likely to happen, and I'll just cover a few that I've been thinking about. First, I think there's going to be less hostility to private equity. We're going to go back to former Assistant Attorney General Macon Delrahim's view that there's no reason to disfavor private equity as divestiture buyers, or in general, more generally, to view them suspiciously. Second, I think for sure there's going to be a pullback in the FTC's competition rulemaking authority. This authority already hangs on a slender reed, and there's a widespread perception that the FTC overreached in banning virtually all non-competes. And third, and more generally, it's pretty reasonably anticipated that there's going to be less pursuit of novel theories, and for that matter, enforcement of statutes like Robinson-Patman. Just because Congress hasn't repealed Robinson-Patman doesn't mean the agencies need to enforce it. Personally, I hope there's also going to be some sustained effort to viewing antitrust as an alternative to regulation. Delrahim terminated old regulatory consent decrees, but there's a lot more that can be done to eliminate anti-competitive regulation, and that seems to be a theme with this administration. And there is work, serious work, the Antitrust Division can do on that, and the FTC. There's a role for both agencies in looking at federal regulations and advocating eliminating the ones that cause the most harm to competition and limit entry. One risk is that the agencies get more involved in industrial policy. Promoting national champions is generally antithetical to promoting competition, but there's a temptation to make antitrust an instrument of industrial policy. In some, I think we're going to continue to have very active enforcement. There will be surprises, I'm sure, but I think there's also going to be a lot of continuity.
Thanks, Alan. Greg, if you'd like to finish up the opening statements.
Sure, Glenn, thanks very much. And thanks to the staff at WLF and everybody who's joined. It's great to be able to at least try to do some predicting and prognosticating today, although, as you mentioned, Glenn, unpredictability may be the hallmark of the next 4 years. I will say that to perhaps state the obvious, from an enforcement perspective, we are facing an unconventional president in terms of his views of DOJ and federal government enforcement generally. I think in his first term, it was more or less a traditional kind of norm based approach. But I think if the president was on this panel, he'd be the first to say that he learned some things from his first term, and he's going to do some things differently. And so I think it will be a less conventional, less norm-based approach across the board with respect to DOJ generally, and certainly enforcement efforts across the government. Nevertheless, I think a few things are somewhat predictable given the general unpredictability. There clearly will be less of a focus by DOJ on civil rights enforcement. We've already seen some efforts in terms of that priority shift at Main Justice. There will be less of a focus, I think it's safe to say, on environmental crimes enforcement. Doesn't mean it's not going to happen at all, but I think it will be less of a focus. And on the kind of the what will happen side, now Attorney General Bondi, she was just confirmed, I guess, yesterday. So she's in place now. She made it clear in her confirmation hearing that she will be focused on the basics, violent crime, counterterrorism, and all the things that I think every AG has said in his or her confirmation hearing. But that's at least how she articulated it in hers. And so I guess I should also add that I don't think that the usual, D to R in this case, or R to D sort of transitions and priorities really will be predictable. So in other words, I don't think we're necessarily going to see a kind of a softening at DOJ or less of an emphasis on corporate crime. In fact, some statistics suggest that during the first Trump term, at least in the realm of, for example, FCPA enforcement, there were more cases brought than there were in the previous 4 years. And so I don't think we're going to necessarily see a kind of hands-off corporate crime type approach. And so I get back to it's going to be unpredictable. It's fun to talk about and speculate about, but I think largely we're going to see a more transactional based enforcement effort as opposed to a traditional or doctrinal sort of based effort. So that's as good as you're going to get from me at this point, Glenn. It's a tough one.
Thanks, Greg, and thanks, Emily and Alan for starting us off there. So, Greg, you noted obviously that the president views Justice Department very differently than past presidents have. What does that mean for enforcement targets in the business community, both from a practical perspective and from sort of trying to sort out where the priorities might be?
Well, I think in a word, it means uncertainty, as we've been sort of talking about already today. I think priorities will change rapidly. Areas of emphasis will change. Areas of focus will change. And it won't be so much, again, on doctrinal or philosophical views as it will who's the potential target, how are they connected to the administration. I think that the White House has made it very clear so far, and the president made it clear that the DOJ won't necessarily be seen as an independent department that can't be interfered with or can't be directed, even when it comes to not just enforcement priorities, but actual enforcement actions. And we've seen some evidence of that already, and I think we'll see more of that going forward.
So how about the relationship between Main Justice and U.S. Attorney's offices? That's always been an interesting situation sometimes. What should we look for that might indicate how those relationships might evolve?
Well, it's difficult, as we all know, for Main Justice to supervise and micromanage the 93 U.S. Attorney's offices. I always enjoyed very much being 3 time zones away from Main Justice when I was the U.S. Attorney in Nevada. But that doesn't mean that there isn't some direction from Main Justice from time to time. And I think we'll see some in this case. We saw an example just already in this administration of a case being dismissed in a district. I'm assuming that direction came from Main Justice and ultimately from the White House. And so the president does have that prerogative. Certainly the AG does, but it's not something that we've seen as a norm across the board in the past. I think we'll see a lot more of that. We'll see a lot more interest on the part of the White House, and as a result, interest on the part of the 5th and 4th floors at Main Justice on cases that are being pursued, investigations that are being pursued around the country that in a normal administration might not get any attention at Main Justice. And so, yeah, I don't, to answer your question directly, I don't think the U.S. Attorney's offices are immune to close supervision in some cases by Washington going forward.
So as often happens routinely when new administrations come in, the acting leadership will issue memos to various agencies. We saw that here with acting Deputy Attorney General Bove issued a memo towards the end of last month for all prosecutors. What was the purpose of that memo, and what do you think its significance is going to be, at least in the short term?
Yeah, if you're speaking of the memo that was really focused on immigration enforcement, I assume that, yeah, so that I think is a good example of something that is perfectly within the normal way that the department, with direction from the president, from the White House, has operated, which is to say, to make it clear that the department, including the U.S. Attorney's offices, is focused on certain types of enforcement actions, whether it's drug trafficking, gun cases, in this case, immigration, perfectly normal, perfectly to be perfectly expected. This one, the devil's in the details, though, in terms of exactly how the department will be managing that. That part of the memo suggested that, for example, and I'm sort of paraphrasing here, but if a U.S. Attorney's office declines an immigration case, it's going to have to explain to Main Justice exactly why. So there will be close supervision, it seems. But that, again, that's a clear area of emphasis for the White House. And it's within the president's prerogative to make it a priority for DOJ.
So will that enforcement in the immigration space include, now and going forward, enforcement against businesses that have not done proper documentation for worker immigration status or work authorization? We have seen that some be a focus in the past, but I'm curious to know if it's going to continue. So it's going to be going forward.
I think that's right, and as you mentioned, Glenn, it's that's always been done. I can recall in my district in Nevada a pretty significant case against actually a very large owner of a very large number of McDonald's franchises, for example. So that wouldn't be anything new, but I think it's fair to say, based on what we've seen so far, anything touching on immigration is going to be a focus and a priority. And so whether it's individuals who are here illegally, whether it's businesses who are hiring those individuals, across the board, immigration will definitely be a focus. Yes.
So you had mentioned FCPA, the Foreign Corrupt Practices Act, and that was a pretty interesting priority for the first Trump administration, both on the criminal and the civil side. Emily, can you speak to the civil side of it? Securities Exchange Commission obviously has responsibility for civil enforcement of the FCPA, and then Greg on the DOJ side. So Emily, go ahead first, and then Greg.
Yeah, so as you noted, the SEC does have a specialized unit that takes charge of FCPA investigations, oftentimes through tips, complaints, and referrals, or TCRs. And the staff there is very well equipped to go abroad, to look at what the bases of the alleged complaint is, and make a recommendation to the commissioners as to whether or not there's an American jurisdictional hook for that particular alleged bribe. And, I think what will be really interesting is as we overlay the dynamic with the Trump administration's tariffs. Oftentimes, many of these complaints originate out of Asia, out of China, whether or not there will be the same sort of cooperation on the investigatory side. That's a very heavily orchestrated and negotiated bilateral and multilateral agreement between the SEC staff and the security enforcement parallels in other countries. So I'm curious to see how that proceeds in an orderly fashion.
On the criminal side, Greg?
I think this is a good example of a federal statute and a past enforcement priority that is not really going to be ignored just because we have a new administration. I think one thing to watch for, though, is if if the department is focused by presidential directive on other things that perhaps it hasn't been as focused on in the past, will there be the bandwidth to continue a focus on things like the FCPA, traditional criminal enforcement areas. And will the department, in light of recent events, have somewhat of a brain drain in terms of people who are really expert in areas like the FCPA, public corruption, other areas, maybe leaving the department, which could cause a de facto de-emphasis on certain areas of enforcement. So I think that's certainly a possibility, but I don't think there's going to be a mandate from the new AG or the DAG or the White House that hands off of companies bribing foreign officials. I wouldn't predict that. So to those out there who in their day jobs advise companies and counsel companies on such matters, yeah, I think that's certainly something that is not going to be an enforcement-free zone going forward.
And then on the DOJ side, Alan, do you think that criminal charges being pursued for behavior that violates the antitrust laws will be a priority for the antitrust division at Justice?
Well, I first have to start by saying I've worked on exactly 2 grand juries, and both of those were in private practice. And my real criminal experience is playing bridge with a bunch of retired DOJ antitrust prosecutors. So with that caveat, traditionally, the criminal program tends to be pretty much insulated from political change from one administration to another. The DOJ antitrust workload statistics came out a couple of weeks ago, and the numbers are down. So my friend Bob Connolly, who used to be the chief of the Philadelphia field office and who has a blog called Cartel Capers, characterized the workload statistics as criminal cases are low and there are no major cartel cases. If you're an optimist, deterrence and compliance works. The other possibility is that wrongdoers have gotten smarter at hiding the collusion, and leniency has lost its appeal as collateral damages have greatly escalated. And his conclusion is it's never one thing. So both are probably true to some extent. I'll spend a minute on Brubaker, which I think is an interesting case. In a lot of ways, it's a garden variety collusion case. And you had one company that made metal or aluminum parts, the other that was partly the folks who designed or installed them. They were convicted not only of collusion and bid rigging in North Carolina, but also convicted of submitting non-collusion affidavits. And as I'm sure you know, and many of your audience know, the Fourth Circuit reversed that with a view that this was not even though this was bid rigging, this is a bid rigging case that was not a per se, or should have been considered under the rule of reason, which makes it sort of like the chipping away of the rule of reason that we've seen on the civil side. But interesting, it's on the criminal side. Supreme Court denied cert, so we won't know what the Supreme Court has to say. But it looks like an outlier case, and I guess if there's a lesson there for the criminal folks at DOJ, it's stay out of the Fourth Circuit.
Probably wise counsel, definitely. Thank you, Alan. Emily, we're going to move a little bit for a few minutes to the SEC. So in past instances where there was a Republican majority, it seemed like the commission pursued enforcement actions kind of more of as a last result. And they only did so if there was materiality in the violations and there was clear investor harm. Do you see that as being sort of the approach that the commission under Paul Atkins would take?
Yeah, definitely. I think he's already been outspoken about regulation by enforcement as something that he really resisted against when he was a commissioner. He's going to be joined by 2 other commissioners, including Hyatt, who's the current acting chair, as well as Commissioner Peirce, who are very outspoken on or against regulation by enforcement. I think the process for opening up an investigation, we'll talk a little bit about that in terms of formal orders, but I think the process is going to be similar. There's often going to be either a tip complaint or referral that comes in post Bernie Madoff that has to be reviewed by human eyes, and there has to be a determination of whether or not there's a basis to open up a matter under investigation or MUI. And then from there, you will also see exam referrals that come in that may lead to enforcement. But I think that the likeliness of having some sort of negotiated resolution, either pre or post Wells notice, is going to be higher. And I don't think you're going to see these kind of like bet the company massive enforcement actions, in an area of law that is undecided without, as you noted, materiality, fraud, intentional fraud, something beyond just like a standard, kind of foot fault, technical default issue.
Reuters reported this week that SEC's interim leadership is requiring commission and lawyers to pre-clear the initiation of all investigations with political appointees. How might this impact SEC enforcement and its business targets?
Yeah, and so for your audience members who aren't as familiar with the enforcement manual, there's a couple of formal procedures in the SEC world. First, a matter is opened as a MUI or a matter under investigation, typically. And that's when, the staff is really looking to see whether or not there's facts that support an alleged securities violation. That matter has to get converted to a formal order of investigation within 60 days. Otherwise, it's closed. You can, in rare circumstances, go right to a formal order. The formal order process typically was designated to allow delegation to lower level senior staff without having to go to the commission, right? Like the commissioners are the client of the SEC. So typically you have to go to your client to get authorization. The formal order process was designated down the line to give assistant directors authority to be able to sign those formal orders. And now what we're hearing is that the commission is going back to the process that was the case under Kazumi. So this isn't unprecedented. There was a process where all formal orders had to be approved by the commission, usually through a memo, and sometimes on the consent calendar before the commission, and sometimes it was actually part of a negotiated discussion. So that all is just going to slow things down. And I think, if I were sitting in staff, I would want to think about what I needed to put in that memo in order to get a formal order in order to continue to go forward. So it may have some deterrence on, really political investigations, but really like the heart of what the SEC does is, deter fraud and look for instances where people are making misrepresentations to investors. They're taking advantage of affinity communities to raise money. And those sort of cases, you're going to see the goodwill to be able to move forward with an investigation on.
So one of the areas that was pretty prominent in using enforcement as a regulatory tool was cryptocurrency during Chairman Gensler's term. What's it going to look like, you think, under this SEC? Do you think the commission's going to set a clear standard, or are they going to wait for Congress to act? Will it pause enforcement actions in the area that don't involve fraud, you think?
All of the above. I'll have an easier answer for you. I think we're going to see legislation on the Hill for sure. There was a Stablecoin Act bill that was introduced this week, and I think that's up for a hearing next week. The SEC has created this crypto task force led by Commissioner Peirce. She's known as the crypto mama. She has been very outspoken in support of the industry and just making sure the industry has a standard process to be able to comply with the securities laws as written. If you go onto the Crypto Task Force website right now, you can request a meeting and you can put in there the basis for your meeting. You can upload documents. I mean, that sort of transparency and interaction with the staff is going to be very different. And then I think to your last point, Glenn, you're right. There's going to be enforcement actions that the SEC decides that it needs to walk away from because the political inertia isn't there in supporting anymore.
There's also a White House level task force with regards to cryptocurrency as well. So it's certainly that would look like one of those areas where even though SEC is an independent agency, there might be a little bit of suasion going on there as well. On the rulemaking side, do you think that rules like climate risk disclosure rule is going to survive, and things like targeted investigations on these things called off-channel communications which was such a big deal last year that we even did a webinar completely on off-channel invest communications, which was kind of an oddball one. Do you think those we'll see those go by the wayside?
I do. Speaking about the climate rule briefly, because I belabored through a webinar for an industry client and went through all the details about the rule and the enforcement mechanisms. And I think about the amount of hours I wasted on that. I think it's gone. I worry about that cottage industry of consultants in the green space as it relates to the SEC rule. Now, the caveat there, of course, is that there are states that are still going to go forward. California has a very aggressive rule. The EU has a very aggressive rule. But in terms of what the SEC was doing to coordinate all of that, I suspect that what happens is there is oral argument that's going to be heard on the Eighth Circuit case. The rule is stayed pending that Eighth Circuit. But we're hearing in other agencies that staff are showing up on behalf of the government and saying, we're here, but we're not going to argue in favor of the government's former position. And I wouldn't be surprised if that's what happens on the climate rule. Off-channel investigations, I think that there's definitely an opportunity for a notice and comment period to repeal. And likewise, other rules that the SEC has been aggressive on. It is my suspicion, and I am not an APA lawyer, that they have to provide notice and comment. So you could see litigation for industry advocate groups that were in support of those rules fighting the withdrawal. But I suspect that will be something that this administration pushes for.
Yeah, the litigation against California's rule is going as well as the Chamber of Commerce at least would hope. I think there was a motion to dismiss denied just the other day by the district court in that case. So that's definitely, like you said, there's always California.
Yep.
We shift back to antitrust, Alan. What is the antitrust division's decision to challenge Hewlett Packard's purchase of Juniper, the transaction that would impact AI enabling networks, tell us?
Well, I think what's interesting is not what it tells us, but how it deals with reactions to the incoming administration, because it certainly puts to rest the view that mergers are going to be open season. People were surprised that the 2023 merger guidelines are cited in the case. The reaction to the filing of the case was kind of surprising, because if you look at the case itself, it's two very large competitors, one an innovator. The presumption of illegality would apply under the 2023 guidelines or the 2010 guidelines, and courts who have heard this already are willing to look at both guidelines. So I think if anything, it says merger enforcement is going to continue, certainly in areas where it's highly concentrated, definitely where you've got an innovative or maverick firm that is being acquired. In a way, it supports the view that there's going to be consistency, as there was. The merger enforcement was pretty good under Macon Delrahim. It continued to be good. There were no settlements for a long time, as you know, under Biden, and there were more cases, which actually I think is a good thing, because you end up getting a stable of people who've got litigation experience, which is something you don't tend to get in antitrust. It's different from like U.S. attorneys' offices. So I think what it says to us is, if you've got a problematic merger, you've got a problematic merger, and you're not going to get a free pass because there's a new administration.
That investigation obviously began during the Biden administration. There are plenty of lawsuits, especially in the big tech space, that began and are still ongoing with the Biden administration. I have to imagine you would agree that most of those, if not all of those, will at least initially continue to go forward.
Yeah, I think they'll get the level of review that they deserve, and if they're meritorious, they'll be pushed forward, and if there's a reason to kill them, they'll be killed.
One case that DOJ filed that's come under a good amount of fire, especially from conservatives, was this suit against RealPage. involving AI to some extent. Do you think that one's going to continue forward?
Now, that's a good question. I think on the first of all, algorithmic pricing is a big and increasing issue. It's going to be an issue. How to deal with it from an antitrust standpoint is an issue. I commented on a paper on this that basically said antitrust law is ill-equipped to deal with algorithmic price setting. The Real Page case to me is probably, at somewhere at or near the limits of what antitrust can do. And I guess if I had to guess, I would guess that there's going to be some serious thinking about this and whether they're going to continue with all the theories and to some extent, these cases are also dependent on the evidence. Just, I'll note that the MDL case, I think you had a plaintiff's firm that knew how to plead to get past a motion to dismiss. Whether the facts are ultimately going to stand up is another question. But I think you've mentioned a good one. This is a topic where antitrust probably needs to be involved, but how aggressively and in what way is an open question.
So one of the other influential voices, in addition to Elon Musk from the tech world, is Mark Andreessen, who's been very vocal about calling for an antitrust philosophy towards technology that helps so-called little tech. How do you see that potentially playing out? And it certainly is not consistent with the consumer welfare standard, which doesn't want antitrust to be used to favor one competitor over another. But definitely curious for your thoughts on that.
Okay, well, I'll dispute you on that last point, because when Macon Delrahim was in, he argued, I think persuasively, that consumer welfare does reach things that you might say go beyond price effects. And in the Google complaint specifically, there are allegations about privacy and so forth, all framed within consumer welfare. So I think consumer welfare is broad enough to deal with these issues. I do think that, to the statement about little tech, if we put aside the big and little and we think about it as incumbent and startup or incumbent and challenger, again, if you look back at the first Trump administration, there was a great deal of emphasis on making sure that incumbents didn't block new entry and didn't extend, one of the complaints was, we'll extend our runway, right? Through an acquisition or through conduct. So I expect we're going to see that. And whether the little tech means smaller established companies, that's not really the way I'm thinking of it. I'm thinking of it more as new companies that may have a better mousetrap and that need to get in, and so you got to keep the path clear for innovation, and that to me is consistent with what the first Trump administration did.
In the healthcare area, FTC has obviously always been very active in challenging drug patent settlements. There's been some talk, obviously, during the Linicon period at FTC that antitrust can help lower drug prices, and that was some talk. Do you see those sort of theories continuing, investigations of PBMs in the Trump FTC especially?
I would say yes, but I think this is going to be given how the FTC is structured, and you've got a powerful chair, and the chair sets the agenda. It's really going to be up to Chairman Ferguson how the priorities play out. But certainly I don't think there's going to be a lessening of there may be a shift in focus from in certain areas, but I think a lot of the healthcare antitrust work is going to continue. FTC obviously has got oodles of experience, and that's its value add or its sweet spot in a lot of ways. And there's concern on the Hill, as you know, bipartisan about some of these issues. So I'd expect a lot of enforcement in the healthcare area, but what in particular, it's kind of hard to say.
So the healthcare industry, especially the drug industry, is very interested and concerned with the Federal False Claims Act. Greg, sort of shifting back to you for a few minutes. So what indications do we have that the first Trump administration from then of whether DOJ will continue to be a vigorous FCA enforcer?
Well, the new Attorney General did get this question during her confirmation hearing, as you may have seen, and did commit to the False Claims Act and DOJ's role in enforcing it. So I don't know that we're going to see a change there. And as long as Senator Grassley's around, there are two things, of course, that everyone in town knows you don't do if you want to stay on Senator Grassley's good side. One is you don't ignore his letters. And the second is you don't support whistleblowers in the False Claims Act. So I think we will see the department continuing to do what it has done in that arena. Although, as you know, there's a bit of a wrinkle with respect to the key TAM provisions because of a case out of Florida that's now on appeal, and of course the department is involved in that case. But in that case, if anyone on the call doesn't know, a federal district court judge in Florida found the key TAM provisions of the False Claims Act to be unconstitutional. Something, an argument that's been kicking around for some time, as many of us know. But this is the first kind of bombshell decision kind of just going there, right? And so on appeal now, ironically, I find this ironic, the judge seems to have been motivated, at least in part, by a recent dissent by Justice Thomas in a case wherein he suggested, and I think was with a concurrence by Justices Barrett and Kavanaugh, if I'm not mistaken.
That's right. Yeah.
Suggested that the right case before the court could lead to a robust discussion and perhaps decision on the constitutionality question. The district court judge in Florida clerked for Justice Thomas. And so the irony, I think, is you have the Justice Thomas wing of the Republican Party, such as it is, sort of suggesting that the key TAM provisions are unconstitutional. But you have an executive, you have a new administration that's very much I think for the most part, in the Thomas wing of the GOP, tasked with kind of preserving its honor, defending its honor, and including before the Supreme Court. So that will be an interesting kind of dilemma that the new Attorney General will have. But as I said, she made it clear in her hearing that at least on the surface, she's all in for the FCA. So we'll see.
So what's interesting is that the Polanski case that you were referring to, where there was the dissent and the two concurrences, that was focused on what DOJ has to do in terms of providing process to the relator in key TAM actions when DOJ wants to dismiss a case. Do you see this Justice Department being more aggressive than the Biden Justice Department was in terms of either taking cases over or entering and dismissing them if they see them being unmeritorious?
I can see the latter being something that we may notice, right? Being more aggressive against cases that don't seem to have merit. But I think this is a complicated one that's too difficult to predict at this point. And a lot of strong feelings on both sides. We'll see what happens in the Florida appeal. But yeah, stay tuned on that one. Very interesting issue.
So, Greg, as a former in-house counsel focused on corporate compliance, sort of from a broader perspective, what advice might you have for in-house counsel on corporate compliance programs? Do you think they remain as important as ever?
I really do, and I say that for two primary reasons. One is that to the extent, and we don't know this for sure, we're speculating, we're talking about it today, but to the extent that the next 4 years kind of results in a less than robust effort at combating corporate crime, which impacts corporate compliance, at least indirectly. That could very well shift. Even if that is what we see, that could change rapidly in 4 years, right? So, you know, corporate America shouldn't just think that if they see signs of kind of a less of an emphasis on compliance on the part of DOJ and other enforcers that they're getting a free pass, because that can shift quickly. The other thing I will suggest as a former chief compliance officer of a big publicly traded international company is that once you sort of let your compliance program wither a little bit, right? It's very, very hard to kind of get it back on track and where it needs to be, particularly with the, you know, the cliche phrase culture of compliance, right? If you're not absolutely dedicated to maintaining that high culture of compliance with respect to line employees, C-suite executives, the board, et cetera, it's really hard to get that back. And in some ways, potentially too late to try to get it back once things slip and all of a sudden you find yourselves on the wrong end of an enforcement action. So my message to compliance officers everywhere is do not in any way be lulled into a sense that it's not going to be a big issue going forward. Keep doing what you're doing. It's the best way to ensure that when you do find yourself as a company on the wrong end of an enforcement action, that you can get yourself out of it in unfavorable terms. If you can show that you had a robust program, you were doing robust training, you took it seriously, you investigated appropriately, you audited effectively, et cetera, and you still had a problem with a rogue employee, you're going to be in much better shape than if you can't really establish any or all of those things when the government asks. So I would say stay on your toes, corporate compliance officers.
Thanks, Greg. It sounds a lot like a blog post that you wrote for us before right at the beginning of the last Trump administration. So same message, right. Certainly. Right. Want to remind everyone, if you do have questions, please use the Q&A function to ask them. Emily, I had mentioned during your introduction that you have an antitrust focus as well, and I thought I'd give you an opportunity to maybe offer some thoughts based on what Alan said, or some different thoughts on the antitrust area.
Yeah, no, I appreciate that. Can you see me taking notes? Alan is such an expert and such a wonderful colleague and partner to think through some of these real theoretical questions. You know, we are involved in an algorithmic case on behalf of a hotel casino that was sued along with other hotel casinos for allegedly using a revenue mechanism to fix rack rates for their hotel. And the DOJ filed a statement of interest in that case. The case is up for appeal with the Ninth Circuit. We are been notified that they are interested in oral argument. So stay tuned on that. But I am very curious to see what the DOJ's presence will be in that case, given that, as Alan said so well, the RealPage case is really pushing the threshold of antitrust law as it relates to using algorithmic software to fix prices, allegedly. And this case certainly falls much short of that on the facts. So, of course, I'm biased. But, you know, I think it's going to be really fascinating to see how the antitrust division of the DOJ uses its resources in this new administration, particularly in the area of big tech, when algorithm and revenue software management programs are all the rage.
So finish up with a couple of questions on environment, social, and governance issues, ESG. SEC under the Biden administration sort of dipped its toe a little bit into that area. How do you see an Atkins-run commission approaching an issue like ESG, Emily?
Yeah, I think he's going to be very cautious to prescribe disclosures to companies in general, particularly in the ESG space. Whether or not the companies voluntarily continue to make those sort of disclosures, then I think the question will be, how rigorous is he on enforcement when we feel like there's been greenwashing or misrepresentations? It's no secret, you know, that the newly sworn in Secretary of Energy, Chris Rice, Denver former Denver CEO of Liberty Energy, was also one of the named plaintiffs in the case against the SEC on the climate disclosure rules. So that cabinet is going to be very resistant to prescribing one size fits all for disclosure regimes in the environmental social governance space.
And Alan, one cause célèbre for conservatives on antitrust is that for an agency like the FTC to pursue collusion charges for ESG collaboration among companies. Do you see that as a thing for the new FTC?
Well, Glenn, I have to say that when now Chairman Ferguson tweeted or whatever, whatever you call it now, his one-pager, one of the points that he made was that he would investigate and prosecute collusion on DEI, ESG, advertiser boycotts, etc. I think that comes across a little more sensational than it really is. I worked at DOJ with Bernie Hollander, who did the smog cases years ago. Under Macon Delrahim, there was an investigation ultimately closed about whether there was an agreement between the car manufacturers to get the California, I'm sure you know this one, to get the California air emission standards in a way to, so you can say, well, okay, these things seem like they're social, but they are in fact, or can be in fact, collusion. So it's not a wacky or necessarily political idea to ask the question whether doing some of these things and agreeing with your rivals to do them, like in the ESG space or whatever, is collusive or not. And with Delrahim's work, that it ended up generating a whistleblower and an OIG investigation, which ultimately said, look, the staff was looking at this before the president tweeted it. And, they got CID authority, they interviewed or did whatever with the car companies and then closed the investigation, and no issues there. So that's a long-winded way of saying, this is not an off the wall issue to look at. It's going to depend on the circumstances, but there are certainly potential cases out there, and then there's the political stuff, where there really isn't a potential case.
Any final thoughts that you want to share, Greg, Emily, before we wrap up?
Emily, I'll defer to you if you have any.
No, please. I mean, just appreciation for so excellently navigating 3 different practice areas. Glenn, your questions are spot on, and I've really appreciated being able to participate today. Thank you.
Well, thank you all for joining us today and participating. We definitely appreciate the expertise that you were able to share with us and your insights. Our next program is going to be next Wednesday, February 12th. We do a briefing on the Supreme Court at midterm each year, and we'll be doing that on February 12th. So if you have an interest in that, you can sign up by going to our website. Also, there's a survey after this, after we log off here. If you could do that real quick, we definitely would appreciate it. Thanks again to Alan, Greg, and Emily for spending their time with us today, and for all those of you who joined in today as well. If you joined late, or if you know somebody who wants to watch this program, it'll be available on our website later on this afternoon as an on-demand.